Well, hello and thank you to everyone that's joined us. Hopefully some more will continue to join us. This afternoon I'm going to be holding a session on leasehold fire safety, looking at service charges and consultation headaches. I'm Emily Jordan, Associate Solicitor at Forbes, and I work alongside Lachlan, McLean, partner, and we deal with all sorts of leasehold matters, both residential and commercial. You'll also be hearing from Scott Jeffries, who's Service Charge Lead at Trafford Housing Trust. So we're going to be looking at where we are now post-Grenfell. Lachlan will then be discussing overlapping duties between freeholders, leaseholders, building managers and agents, and also looking at mixed-use premises. We'll then go on to look at recovery of costs for fire safety works and just pick up on a few points on Section 20 consultation. There we go. So just to let you know that the session will be recorded. If you've got any questions as we go through, please pop them in the Q&A box. We'll try and answer them as we go through the session. So you might have seen a parliamentary briefing paper was recently published just on 16th of June, entitled Leasehold High-Rise Blocks, Who Pays for Fire Safety Work. It is a long read, but it's definitely worthwhile. So if you'd like me to send you a link, just let me know. I'm just going to briefly mention some of the points that are discussed in the paper. So at the 31st of May 2020, 455 residential blocks and public buildings over 18 metres in England were identified as having ACM cladding. So that's, of course, the same or similar type cladding that was applied to Grenfell Tower. Now, of those 455 blocks, 300 were yet to be remediated at the end of May. And 154 of those buildings are social housing blocks owned or managed by a local authority or housing association. Of course, remediation work is complex and the associated costs are significant. So the question of who's responsible for paying for remedial works has been at the forefront of debates. On the 16th of May 2018, the government announced it would meet the reasonable cost of the removal and replacement of unsafe cladding by councils and housing associations, which was estimated at £400 million. But that funding only covers the removal and replacement of unsafe cladding. The government has, however, said that it will continue to provide financial flexibilities for other essential fire safety measures. And at the 31st of May 2020, the Social Sector ACM Cladding Remediation Fund had approved £270 million for the removal and replacement of unsafe ACM. Skip forward a couple of years, and in the March 2020 budget, the government announced that it would provide £1 billion over the next year to support the remediation of unsafe non-ACM cladding, both in the private and the social housing sectors. So that's in addition to the £600 million for ACM cladding. However, in order to access this funding, social landlords must establish that they're unable to pay and provide a business case setting out its financial position and options. And it must also notify the regulator of social housing. Now, there are significant ongoing concerns regarding the funding, including the adequacy of funding, certain exclusions, and the impact on leaseholders who face rising costs and are unable to sell or remortgage their houses. Fire safety bill was introduced in the House of Commons in March, and the bill is intended to put beyond doubt that the fire safety order will require building owners and managers of multi-occupied residential premises of any height to fully consider and mitigate the risks of any external wall systems and front doors. And Lachlan will be speaking more on the fire safety order and on mixed-use premises. Now, the prioritisation and the cost of fire safety work in the absence of additional funding is likely to have an impact on other areas of social landlords' activities, such as investment in new affordable housing development and capital investment in improving the housing stock. And it will also put an upward pressure on social rents. So how can these costs be recovered? Of course, when major works are carried out on blocks owned by social landlords, there's no additional cost to be met by secure and assured tenants. But long leaseholders in these blocks could be liable to pay a contribution towards the cost, depending on the wording in their leases. And this can result in individuals facing some substantial bills. In the aftermath of Grenfell, The government made repeated references to a commitment by social landlords not to recover the cost of remedial works associated with cladding safety from long leaseholders. And David Orr, who was then the CEO of the National Housing Federation, responded to this saying, "As freeholders of leasehold properties, our members have legal responsibilities as part of their leases and are therefore legally entitled to recoup the reasonable costs through service charges." Now, some social landlords have sought to recover a proportion of the costs associated with fire safety works from their long leaseholders. One example is the London Borough of Wandsworth. They resolved to retrofit sprinklers in all of its blocks of 10 stories or higher. And they did obtain legal advice that the costs would be recoverable, but the cost was estimated to be around £3,000 to £4,000 per unit. Of course, the leaseholders had concerns, and the council did resolve to the first tier tribunal for a decision on recharging the cost to the leaseholders. Leaseholders applied to strike out the case, and in December last year, the tribunal upheld the leaseholders' application. The tribunal found that the council was not entitled to ask for a blanket determination, and said that if the council wished to proceed, it would have to consider each block of flats individually. So as you can see, even if you are going to the tribunal for determinations on these matters, it is on a block by block basis, so both timely and costly. Now, there has been limited reference to the potential for authorities to be challenged for breach of their fiduciary duty where no attempt is made to recover contributions from long leaseholders if the leases do allow for it. And during a Westminster Hall debate on fire safety and cladding in March 2018, Andy Slaughter MP made the point that not charging leaseholders in social housing blocks for these works meant that ultimately the money for them will come from tenants. This is now less of an issue in light of the government's decision to fund certain remedial works in the social housing sector, but it is still an interesting point and of course relevant to the cost of other fire safety works not covered by the fund. Government has also said that building owners should also explore every opportunity to fund cladding work via those originally responsible for the defects and warranty claims before seeking government funding or passing the cost on to leaseholders. I don't know if anyone has any experience in that, but as it's predicted that the government fund is not large enough to cover the total remediation costs for all affected blocks, which is estimated to be as much as £3 or £3.5 billion, then these are viable options. Also, the fund doesn't cover blocks that are under 18 metres tall, so there is a real likelihood that landlords will turn to its leaseholders to recover remediation costs. Also, the fund is exclusively for the removal of and replacement of cladding. And if the government was to fund remediation costs for all fire safety defects, it could cost up to £15 billion. And in addition, insurance premiums for affected buildings are likely to have risen substantially, which will impact on service charges payable by leaseholders. So that just gives us a little bit of an overview and kind of sets the scene as to where we are now. And one of the things that I've picked up on there is that the regulator is to be notified should you be looking to tap into these funds. And I know, Scott, that you've mentioned that there's some concern around social landlords that the effect that this could have. Don't know if you've got any comments that you want to make at the moment. Oh, you're muted, Scott, sorry.
Thank you for spotting that deliberate mistake. Yeah, it was mentioned at the NLG conference for service charges recently that landlords who do want to sort of apply for this fund, this £1 billion, run the risk of being downgraded. And, you know, therefore, it's sort of a double-edged sword. You apply for the funds because you don't want to incur the charges for the leaseholders, but then the regulator could punish your company by downgrading you because you're asking for funding. So, it seems to me like the whole industry at the minute, people are sort of afraid to even apply for this money in the first place. So, and then it begs the question: okay, are we going to make leaseholders pay via service charges or whatever other mechanisms are in the leases, or ultimately, as you just mentioned, is that going to be borne from rent? Because that's the only other income, isn't it? So I think there's a bit of it's more of a moral question. You know, do we burden the cost of this work onto people who are probably the poorest in society, but, you know, renting properties? So that would be my concern is, well, the government needs to give us better guidance really on, you know, whether we can apply for this money without being punished for it.
Yeah, definitely. Cross over to Lachlan. I'll just try and get his slides up.
Sorry about that. We'll take it in turns to have our fun and games with technical issues. That's the way these things often pan out. Yes, we do apologise. We've not got slides for all the parts of this session, but we've managed to get some together and to have them work for the electronic presentation for this part of it. Again, mostly illustrative. So the key things are highlighting the outline issues. Well, having had that scene set for us very well by Emily, one of the things we have to bear in mind as well is what to do in terms of where you have complex interrelationships for these legal health and safety duties. Most of you'll be aware that there are volumes of health and safety duties imposed on landlords at any given point in time anyway. We don't have time to examine them all, but I'm going to touch on a couple of pointers about the issues which can arise where you can have these overlapping different areas, especially in the context of fire safety. Next slide, please. So the first of these is where you might have, in fact, more than one person or organisation which owes simultaneous duties under the legislation. And the second of these that we're going to look at, again, very much in outline, is where duties under different pieces of legislation might overlap because the nature of the property usage is different. Next slide, please. So looking firstly then at multiple duty holders, and this is born out of my own experience of having to advise on some of these in the immediate aftermath of Grenfell. In a high-rise building, it's increasingly common with modern urban developments that there may be multiple organisations involved in the ownership or management of the building. For example, looking at our diagram here, you might have the freeholder of the entire site. That could be a private landowning, land banking fund, or it could be a council. And the block itself may be held under a long lease by a development company or maybe some kind of a joint venture. If the lower levels of the building are for commercial use with residential flats above, then these lower levels might be subleased to a commercial entity with the residential areas held under a different lease, perhaps to a housing association or a market rent or home ownership subsidiary. Each of those flats might then be individually subleased on a variety of long leases, shared ownership leases, or weekly and monthly tenancies. Depending on the management structure which has been adopted, it is commonplace to have a specifically designated management company as a party to some or all of these leases to carry out the management functions of the building owner or the head lessee. And if that wasn't enough, to cap it all off, it is quite usual for that designated management company to instruct the services of a professional managing agent to actually carry out the day-to-day running of the building. This all sounds complicated, and quite frankly it is. The issue in this kind of situation is to unpick who actually holds the legal duties in terms of health and safety. Now, this can be a very technical exercise, as it will often hinge on the precise wording of the legislation in question, as well as the leases that we're dealing with. For example, the test under the Regulatory Reform Fire Safety Order 2005 is under Regulation 3. This refers to the concept of a responsible person, and it's defined as, in relation to a workplace, the employer, if the workplace is to any extent under that person's control. And in relation to any premises not falling within that area, it is either the person who has control of the premises, as occupier or otherwise, in connection with the carrying on by him of a trade, business or other undertaking, whether profitable or not, or the owner, where the person in control of the premises doesn't have control in connection with the carrying on of a trade, business or undertaking by that person. New slide, please. Now, the issue here is what is meant by control, because that's one of the words which kept popping up during that part of the regulation. Now, where a property is being leased out, then the lessor gives away overall control of those premises to the lessee or tenant. However, Article 5 of the order provides that there are parallel duties under the FSO on every person other than the responsible person who has, to any extent, control of those premises, so far as the requirements relate to matters within their control. Now, the use of the words "to any extent" and "so far as the requirements relate to matters within their control" is significant. It could turn on, firstly, whether the lease provides that repairing responsibilities for the demised parts are the responsibility of the landlord or of the tenant, and secondly, whether and what powers are reserved by the landlords to enforce the tenant's compliance with repairing obligations which affect fire safety. The landlord may still be deemed to have an element of control over these parts and have parallel duties under the FSO. If the management company owes these obligations under the lease, then it too could be deemed to have an element of control. Lastly, if the service contract between the management company and the managing agent requires the agent to ensure fire safety compliance on behalf of the landlord or the management company, then the managing agent could also be held to have an element of control. Now, the FSO envisages that there is only one responsible person as such, but where there are further organisations which owe these parallel duties, then they should cooperate to ensure that health and safety is protected. Exactly how that is done is not necessarily so straightforward though, and it is always advisable to make sure that it is clearly set out in the terms of the lease or any managing agent contract. So in contrast, under the Gas Safety Installation and Use Regulations 1998, for those of you who are familiar with that legislation, there's a very clear stratification of responsibilities, that the Regulation 36 duty for an annual gas safety check only applies to residential premises held under a tenancy for less than 7 years, and that primary duty is only held by the immediate landlord of such a tenancy, regardless of who has control. So there's very different provisions according to whether you're dealing with fire safety or gas safety, even though the two will definitely overlap at some point. There are similar quirks and nuances of wording depending on whether the regulation in question relates to fire safety, asbestos control, or Legionella. Unfortunately, there is no one-size-fits-all approach. In a multi-ownership or multi-occupancy building, it is essential to ensure that this is carefully investigated to work out who the key duty holders are for the building under each set of legislation. New slide, please. Again, coming back to the fire safety order, you will have seen that it breaks down the definition of the responsible person according to whether the premises or the relevant parts of the premises are a workplace or not. Aside from that, the FSO applies to the common parts of blocks of flats, but does not apply to individual flats themselves. For any parts of a building which are for residential use and subject to a lease or tenancy, then the Housing Act 2004 would apply instead. This created the Housing Health and Safety Rating System, which uses a scoring matrix to determine whether a Category 1 or Category 2 housing safety hazard exists on residential premises. Next slide, please. The enforcing authority for the FSO is the local fire and rescue service, whereas the enforcing authority for the Housing Act 2004 is the local housing council authority. A further complexity is that the safety of the common parts from fire can sometimes rely on fire safety measures within the flats into which there is no power of entry by the Fire and Rescue Authority, or you can rely upon the power to make requirements under the FSO. However, there is that sort of power available to a local council under the Housing Act 2004 instead. Fire and housing authorities must therefore coordinate their efforts regarding investigation and enforcement. Now, traditionally, the distinction was that housing authorities led on residential premises, whereas fire authorities led on commercial or mixed-use premises. But in the wake of Grenfell, the fire authorities do seem to be taking a more assertive approach in relation to high-rise management, even if it is exclusively residential. The subtleties of this legislative overlap can lead to some anomalies arising. For example, if the front door of an individual flat in a block is not included in the lease to the leaseholder, then it remains under the control of the landlord. And so the landlord owes fire safety duties under the FSO 2005, and this can be enforced by the Fire and Rescue Service. However, if the front door has been included in the lease, then the landlord has lost control over the front door. But the landlord might still owe a duty under the lease terms to keep the front door in repair, and would thus have a power of entry for those purposes, meaning that they could still owe the parallel duties, albeit not as a responsible person. Whether you end up with a standoff between the landlord and the leaseholder regarding replacement of a front door to comply with current fire standards, the landlord may be forced to refer the matter over to both the Fire and Rescue Authority and the local housing authority for them to take action directly against the leaseholder. In an older tower block, with some flats having been sold off by the council and some later having been sold off following a stock transfer, there could be different lease terms applying to different flats within the same block. This is undoubtedly a logistical nightmare, but it shows the importance of knowing which lease variants you have in your buildings and who retains control over the key property components. In addition, as we saw earlier, the gas safety annual check requirement only applies to residential premises, but there are similar general duties owed in respect of a workplace under Regulation 35 instead. Additionally, gas pipe work or an exhaust flue passing through commercial premises could still need an annual safety check if it ultimately serves tenanted residential premises elsewhere in the building. New slide, please. So appreciate there's a lot to take in there, but the key points which we need to remember are these. Firstly, fire safety is almost never the sole responsibility of just one individual or organisation where you have mixed-use premises or multi-occupancy premises. Secondly, there is no one-size-fits-all approach, unfortunately. Every high-rise building must be assessed on its own merits. And indeed, this is one of the requirements of the 2005 order, is that every set of premises to which the order applies has to have its own risk management plan. Indeed, every property which you have some interest in any high-rise premises needs to be assessed in depth, even if it's the only one that you have in that building. And even if you are not the main owner or user of the building, you are likely to have some degree of parallel duties in some regard. And so you need to ensure that, firstly, you know who is the primary duty holder, and secondly, that there is an appropriate plan in place. Lastly, if you are the main duty holder in relation to premises, then you need to be in contact with the other users of the building so that everyone knows clearly what their roles and responsibilities are. Now, these are areas where certainly we have provided advice to landlords, and I've had to unpick a myriad of different leasehold interests and land registry titles. And if it needs doing, then there's certainly something we can assist with going forwards.
Thanks, Lachlan. Just see if we've got any questions there. I've had a question. If this is the case for front doors, are we unable to charge for the replacement of the front doors if they are not mentioned as the leaseholder's responsibility within the lease?
Yeah, well, unfortunately, we always have to look at the lease terms very carefully in these circumstances, and where you are the landlord and you have a repairing responsibility, then usually there'll be in relation to a piece of a property component, usually there'll be an ability to then recharge the leaseholder for those works. It depends, though, again, on what exactly the terminology covers. So I think, Emily, I can't remember, are you going to be looking at some of the differences between repairs and improvements?
Yeah, I'll touch on fire doors in that respect.
Yeah, so Emily's going to be looking at that a little bit. But if you've got a situation where, and again, it can depend on whether you've got implied repairing obligations which have been inserted by the Housing Act 1985 for the right to buy, or whether it's pre-85, or whether it's a private development, you can end up with different responsibilities and different powers accordingly. So in terms of if they're not mentioned as the leaseholder's responsibility within the lease, it depends on whether there's any implied repairing obligation, and also what the service charge element covers in relation to that. Normally, if you retain the responsibility for repairing the door in question, then it's you're able to service charge for it, but it depends on the terms of the lease. I see we've got another question as well to say, also, should this follow the same process for a Section 20 consultation, or is it classed as an exemption? So, I mean, Emily's going to be discussing a little bit about some of the procurement issues in Section 20 overlap, but the Section 20 consultation requirements are a general application in situations where you're going to be remitting a service charge to your leaseholders. There are certain exemptions which can follow, but they generally have to be approved by a tribunal. Emily, can you just remind me, are you going to be covering dispensation at all in your section?
A little, but we can expand if we need to.
Yeah, because I think the key thing is that that if you are going to be looking for an exemption where it would otherwise trigger the Section 20 process, you normally have to get permission from the tribunal to dispense from that. Right, I've had another question come in to say, in terms of sprinkler systems that have been installed, can we enforce access to assess and maintain it? And can we recharge for this? I actually had a similar, there's also a related query from another client about this the other day. Again, it would depend on the wording of the lease in question, but normally where you've got, for leasehold properties anyway, certainly for tenanted properties, you know, your weekly and monthly tenancies, you have implied statutory implied ability to seek entry to the property under Section 11 of the Landlord and Tenant Act 1985. That doesn't necessarily give you permission to force entry, but certainly if the tenant doesn't allow access, you can get a court injunction to require them to allow access. But that's in weekly and monthly short-term tenancies. In terms of leases, it will normally depend again on the terms of the lease. I'd hope that normally a well-drafted lease would reserve you a right to enter the premises, again enforceable through court injunction, in order to carry out, at least at the bare minimum, an inspection of any internal components. If it classes as a landlord's fixture or fitting, and it's one where you're obliged to maintain it, then again normally there'll be a right of entry or right to request entry in order to maintain it. But again, unfortunately, it does depend on making sure that the lease has been appropriately drafted, and this can sometimes be one of the problems you get with older leases, is they don't always anticipate these kind of scenarios. If you don't have a right of entry for those purposes, and I think we would suggests defaulting back to what we discussed previously, which is that it would then fall under the remit of the local housing authority to request entry to the property in order to establish whether a housing hazard exists or not, and they would then be in a better position to enforce their statutory powers. Sometimes as well, the fire and rescue department have a little bit more goodwill from the public. So if they were to make it a fire and safety issue, to say that they required entry, although they might not have a statutory power of entry, you might find that the leaseholders are a bit more willing to listen to them and their perspective. That might not help you if your leaseholder is like like a buy-to-let or property rental investment company. But there are alternatives which you can pursue if that doesn't work. Okay.
Could I just jump in on that? Just that one topic in that. I guess it would depend as well if it was retrofitted, because the leases would have been drafted before they've had the sprinkler system in, so they wouldn't have even had a chance to put in the potential clause in the first place. So I think that's where companies will probably fall foul of not being able to recharge for the works. But obviously there are elements within people's demised properties where you can service charge for them. So I'm thinking like door entry systems where we need access to repair certain elements. They're still considered communal, even though they're within a demised area, as long as the lease sort of describes it that way. Things like soil pipes or other piping, water piping. So yeah, I think that's more of a problem with the retrofitting. If you're planning on, like I have a closer relationship with our developer team, if they're planning on putting sprinklers in and we know we're going to be maintaining those sprinklers, then we'll make sure it's in the lease specifically to protect us. Okay.
Yeah, and I think that's a brilliant point, Scott. It is very difficult when when you're setting up a new property. You've got more flexibility to make sure that these kind of little I's being dotted and T's crossed. It is a lot harder when you're retrofitting stuff in, especially if you've got a tower block with over 100 residents in. You're not going to be able to get secure lease variations for all of those leases to make sure that's explicitly covered. And this is unfortunately is why modern leases are so long, is because they try to cover every potential eventuality. Another option that's just occurred to me as well as a possible solution, if you've got one term that's often tucked away into leases is that the landlord can recover their costs of complying with any statutory notices which have been served on them by a relevant authority, and so that can sometimes be a way around it, is if you could almost kind of conspire with the relevant authority to get them to serve one of these notices on you as a last resort, and then you could try and recover it through that kind of a service charge possibly as well. It depends ultimately on the terms of the lease in question, but that's one option which I think I remember suggesting for one client, again in the aftermath of Grenfell, where they were a managing agent for a set of leases that weren't particularly well drafted. And one loophole that we found which would give them a way of getting around it was if we got the local authority to serve enforcement notices on them, then that would then trigger a clause in the lease which would allow them to go and do the remedial works and invoice the leaseholders. So yeah, you sometimes have to be a bit inventive, definitely, when you're doing retrofitting stuff to find something to hang your hat on.
It's just said, when you're looking at your leases to see if you can recharge, just remember to check all of your leases. Don't assume that all of the leases in one block or one scheme will be the same. Particularly if you've got right to buy or right to acquire leases, it might not be as expressive as your older long leases. Check the wording carefully as to what you can charge for. Specific words, does it refer to repairs, improvements, renewal? Are there any other issues? We'll come on to talk about surveyors' costs. And are there any specific exclusions such as structural defects? It is a question of degree in every individual case as to whether works will fall within the scope of a covenant to repair. But there have been a number of different factors identified in case law, which is helpful. And often judges have defined repair by contrasting it to other types of work, such as renewal or improvement. There's one classic definition that said repair is restoration by renewal or replacement of subsidiary parts of a whole. Renewal, as distinguished as distinguished from repair is reconstruction of the entirety, meaning the entirety, not necessarily the whole, but substantially the whole subject matter under discussion. But of course, there are other concepts which border upon repair, such as an improvement and alterations, but they are distinguishable from repair. Lots of circumstances to take into account when determining if it is a repair. You could look at the nature of the building, of course, the terms of the lease, the state of the building at the date of the lease, the nature of the defects sought to be rectified, the cost of the proposed works, who's going to pay for them, value of the building and its expected lifespan, and the effect on its value and lifespan when the works are done. So there is a lot to consider, and there is a lot of case law on repairs and improvements, but each case will turn on its own facts. Of course, for something to be a repair, it must have been in disrepair beforehand, or at least near the end of its expected lifespan. And preemptive repairs might be taken out. I think one classic example is on a roof, to carry out the repairs before it actually gets into a state of disrepair. But where you are doing preemptive repairs, it does create a bit of a grey area. We'll come on to discuss doors in particular, but if you do have something that is operationally functional but not compliant with current building regulations, it's unlikely to be held in disrepair. The situation might though be different, where you've had a risk assessment done that finds, for example, that panelling must be removed in order to comply with your wider health and safety obligations. You might receive recommendations or requirements in those risk assessments that you need to install apparatus that was perhaps not previously at the premises. And if you do a replacement like for like, it is more straightforward, but where the replacement is different to what was there before, it's likely to be considered an improvement. I think the important thing to remember there is if leaseholders do challenge these costs at the first tier tribunal, it's going to be crucial for you to have good expert evidence as to whether the works are a repair or a replacement. And given that Grenfell was fairly recent in terms of, well, legally speaking, we've not found any reported cases on the replacement of cladding. Like I said, one matter that does come up regularly is the issue of fire doors. So where an existing fire door functions adequately, but health and safety assessments require its replacement, would you consider that a repair or an improvement to replace it? We think that where there's been a change in fire safety standards, it would be a repair. But this is again where evidence of the door being in disrepair becomes crucial. And there is one case that, apologies, I did have on a slide, but we have had a few issues with the slides. If anyone wants me to send them the title of this case, I can do. It's Southwark Council and various lessees of the St Saviour's estate. It's a 2017 case in the Upper Tribunal. The Upper Tribunal was considering whether the council was entitled to charge leaseholders for works to replace communal doors and front entrance doors carried out during a fire safety improvement works on the estate. So the council had a risk assessment done, and it did identify some front doors that needed replacement, but it said that further assessment of the other doors should be carried out before doing the works. Unfortunately, the council didn't get the further assessment done. They just went ahead and replaced all of the front doors, and they actually up-spec'd them. So they put in doors that went beyond what was actually required in order to meet regulations. They then sought to recover full costs from leaseholders. It was common ground that the council could only charge for the replacement of doors that had been in disrepair. But interestingly, the first tier tribunal rejected the evidence of the council surveyor, as he said he wasn't an expert in fire resistance. And the first tier tribunal held that only replacement of the doors where there had been a fire safety assessment and recommendation could be recharged. And in the absence of a full survey, first tier tribunal exercised its discretion to restrict the council in recovering just 50% of other fire safety work, as its necessity couldn't be shown. And the council did appeal to the Upper Tribunal, who rejected their appeal. So I think that just highlights the importance of getting your assessments done, only doing what is necessary, and getting your expert evidence in place. I think, Scott, you've got some comments to make on where the wording in leases can restrict improvements. If you just unmute, Scott. Thanks.
Yeah, you can tell I'm really experienced at this, can't you? Yeah, so I've heard of a case whereby there was an improvement clause within the lease, but it was a bit vague as to what area of the building was allowed to be improved and recharged. So I think the lease said words along the lines of a reasonable part of the cost incurred or to be incurred by council in carrying out improvements to the property, but not specifically to the building. And the case in hand was actually an ex-solicitor. So they read their lease, they knew it very well, and sort of picked up on this and said, yes, your section 20, everything you've done, fine, but I still don't feel that I have to pay for this works because I'm not responsible for paying for improvements to the building, just to the property. Speaking to various different experts about this particular case, and I think generally it would be something that if we decided to go to a tribunal, or then there's the potential to defend the charge still, but then there's a risk to reputation, etc. And do we really want a legal case for something that isn't going to be that substantial? And it could open it up to lots of other people and challenging as well. So yeah, you just got to be careful with, even if you think you've got an improvement clause within your lease, that it is an improvement clause for the whole of the building and not specific to a property. Yeah, that was that.
Yeah, I don't think we can stress enough that it all comes down to the wording of your leases. We've had another question. Can FRA works be deductible from sinking funds rather than adding or increasing a yearly service charge?
Yeah, well, I was going to say, I don't know if you want me to make a few remarks about that, Emily, but it again, I feel like we're on a loop here, but it does depend on the wording of the clauses. And the difficulty, I think, with sinking fund clauses is that they're, again, depending if they're older leases, you tend not to see sinking fund clauses in right to buys, but you do in other older developments. They do tend to be the ones that pay for the major capital expenditure, but that was back in the days when you'd be able to get a little bit more money for your, a better value for money, and those items used to not wear out quite so quickly. More modern leases will tend to give more flexibility, and you don't have this kind of bright line distinction between a sinking fund and your annual service charge. And a well-drafted lease will give you a general power to accumulate a reserve, whether that's a long-term reserve or a periodic, sort of 5-year rolling reserve or whatever. Some older right-to-buy leases, unfortunately, lump everything in together and you just demand everything on an annual basis, and that's it. Your costs can be £100 1 year and £10,000 the next. And some will draw a distinction between capital works, which are invoiced as a one-off and then payable immediately, versus regular running repairs and maintenance, which are then payable over the course of a year quite frequently. So yeah, there isn't any one size fits all approach. I think we do, again, you have to check how well the clause is drafted as to what exactly is covered in the sinking fund. I did one advice where the client wanted, in fact, actually they wanted to raid the sinking fund to pay for certain capital works because the sinking fund was doing rather well. But I pointed out that unfortunately the sinking fund didn't quite cover works in question they wanted to do. It can work the other way as well. Sometimes you feel like you would like to pay for it over a period of 5 years, but you can only bring it out of the sinking fund even if it's not got any money in it. So you can end up being a bit stymied by the wording of your lease, and you can end up with different lease terms on the same development as well, unfortunately. There's not an awful lot you can do about that, I'm afraid. I don't know if you've got any other experiences of your own, Emily.
No, I think it ties into another question that's been raised. If the front doors to flats don't meet health and safety regs anymore, are they then classed as repairs? I think that just goes back to what we said about getting your risk assessments done, and if it's found that they don't comply with the regulations, then they obviously do need a replacement, and that's when you're going to be looking at your lease to see whether it's included as something that could be recharged. And then we've been asked, if so, does that mean we can't treat them as renewals and get them replaced through Section 20? How would we go about collecting for those? I think that links back to what Lachlan was just saying, is look at your lease.
Yeah, ultimately you could be left in a very unfortunate position where if your lease terms don't allow you to recover certain costs, depending on the nature of the works you have to carry out, you could be left in a rather awkward position where you're having to fund them yourselves. Under these sort of circumstances, if anything, that might be quite a handy opportunity to go to the remediation fund for this kind of situation. I know this is for cladding, but if there's ever any kind of wider or alternative, if you're stuck in a situation where you literally cannot recover the cost through service charge and it's not repair, because the thing is, if your lease terms are inadequate in terms of dealing with repairs, then you can apply to the tribunal in order for a widespread variation of leases of blocks of flats in order to make them adequate, and the tribunal does have a power to vary leases of flats where it's in order to deal with repairs or insurance. I think the problem is these borderline issues where it's not quite repair, it's not quite improvement, but it's kind of a grey area in between. And I think Emily's quite right to point out that you need to have very good expert evidence which demonstrates what exactly it is you are trying to do and why those works are necessary. In order for you're having to sort of look at a broader definition of repair in effect and try to argue that it's not just functional in terms of it being a door, but it's actually functional in being a safe door that will actually protect people against fire. And it's a developing area, and we don't have an awful lot of litigated cases about it. That's that one that Emily highlighted, and that just stressed the importance of making sure you get the assessment of it right from the outset.
Talking of developing areas and grey areas, there's one thing in particular in relation to Section 20 consultation that we've had flagged a couple of times recently, and it's the issue of EWS1 surveys. We understand that mortgage lenders are refusing to lend unless the survey's been performed. Those of you that not come across it, the EWS1 form was introduced last December. It came from collaborations between mortgage and housing market trade bodies and industry experts, including RICS. And the process is a set way for a building owner to confirm to valuers and lenders that an external cladding system on residential buildings above 18 metres has been assessed by a suitable expert. And I understand that not every building above 18 metres high will require an EWS form. It's just those with some form of combustible cladding or combustible material on balconies. There might be some exceptions where buildings below 18 metres, where there's specific concerns that they'll require an EWS form as well. And the process involves a qualified professional conducting a fire risk assessment on the external wall system before signing off an EWS1 form, and that's valid for the entire building for 5 years. But of course, if you've just got a sole leaseholder of one flat looking to remortgage or sell their leasehold interest, they're potentially going to need to get this EWS1 form completed. And understand the cost of such a survey is substantial. So there could be potentially massive cost implications for those leaseholders, or if you decide as a landlord to do it for yourselves. You might even find that the assessment's done and no fire safety defects are found. But until it's mandatory for landlords to comply with EWS, we'd suggest looking at your lease to see if you can shoehorn the cost into a sweeping up clause, one that deals with complying with legislation. The alternatives to a single leaseholder paying would be obviously that the landlord pays for it, or you could potentially have a whip round all the leaseholders in the block on the basis that the form is valid for 5 years. So should anyone else seek to sell or remortgage their flat in that time, they would have the form ready. And if the form isn't completed, then each of the leaseholders' flats are likely to be devalued. As well, when you're considering as a landlord whether you should bear this cost, you should weigh up the risk of incurring greater costs if you end up in spin-off litigation and a service charge dispute with leaseholders. Another option that we thought of might be to set aside money in a reserve fund over 5 years to spread the costs out for leaseholders. Going back to the Section 20 consultation point, assuming that the leases allow for these fees to be recharged as service charges and that you do intend to recharge, but you need to carry out Section 20 consultation. Well, the main consideration to have is whether the cost is in relation to qualifying works or a qualifying long-term agreement. I don't consider it to be a qualifying long-term agreement as it's not for more than 12 months. We've not come across any case law, though, which provides a definition of qualifying works. There's a leading case on qualifying works, which is Phillips and Francis, but it doesn't actually define works. So I do think there's merit in the argument that the costs of an EWS1 survey would fall between the gap of qualifying works and a qualifying long-term agreement. So if you did decide to recover the costs from leaseholders, you could still opt to proceed with consultation on the assumption that it does amount to qualifying works, even though we're not sure if it does. I don't know if it would come over OJU, and you might also struggle to get at least 2 estimates for the purposes of full consultation. So I've read that there is a lack of qualified insured fire engineers that are able to undertake these EWS1 surveys. So another option may be that you follow the consultation procedure but adapt it. So for example, if you can only get 1 estimate, you explain to leaseholders that although the consultation isn't strictly required, you've opted to follow the process. And then if there were any challenges to costs at the tribunal, you'd be able to demonstrate that you attempted to carry out consultation. You could also consider applying for dispensation at an earlier stage, but of course that would need to be on a block-by-block basis. If your leases didn't allow for the recovery of surveyors' fees, I've mentioned previously the government is looking to extend the remediation fund, and they're specifically considering whether to extend it to allow payment of these surveyors' fees. The Fire and Building Safety Minister, Lord Greenall, he's recently held talks with RICS in an attempt to resolve confusion over this form. He said that it's caused confusion with many banks unwilling to sign mortgages until the form has been signed, and that it's being blamed for a hiatus for second-hand flat sales, with nervous fire safety experts unwilling to sign off buildings as safe in case they're held responsible in the event of a fire. So obviously it's a fairly new process, and clearly there's teething problems, which I'm sure many of you will be experiencing. So it's something that I suggest you keep a close eye on as to whether the government does announce an extension of the remediation fund, and hopefully there'll be some more guidance out there and reassurance for the surveyors that are carrying out these surveys. Just some quick general points as well in relation to Section 20. Scott actually mentioned before that he works closely with the development team, and I think whenever you're carrying out consultation, there should be a very close liaison between your procurement division and your service charge division. Make sure you're working at the same speed. We've said that there could be difficulties completing consultation if you can't get 2 estimates. There might not be many contractors around wanting to do the works, or if the works are urgent, that can cause issues. So that can be another situation where you might look at dispensation. And also complexities can arise in relation to consultation inside procurement frameworks, or where you've got a DPS approved supplier list, which in itself didn't require consultation. But now that you're doing these works, you can't invite nominations, and it wouldn't be under OJU either. So it's just a few points just wanted to quickly cover. I know we've not got long left, but just wanted to check, Scott, if there's any more comments you have or any more questions people want to raise.
Just on, like you said, if the government does extend the fund to allow other works, remedial works or surveys, again, it's just that question of, will that impact on us in terms of the regulator? And I think that's, from speaking to other sort of housing association people, that is the main concern. It's almost like a reluctance to even attempt to get the funding because we don't want to be marked down for using it. So again, then it becomes do we check every single lease? Do we do a Section 20, etc., etc.? And there you sort of two big points really. And until we get a better clarification from the government on that, there's a reluctance to do a Section 20 and to recharge leaseholders as well. But if the government do say, it is only for housing associations that are in desperate need for the money to get the work done, I do think then housing associations have got to really then service charge the leaseholders. I don't see it as being fair in any other way, unfortunately.
Yeah, I was going to say, try not to be too political about this, but I think one of the problems is, certainly if you read the parliamentary briefing that we mentioned at the outset, it does make some rather pointed, if veiled, criticism of the government's handling of the whole thing. And I think the difficulty is there's been so many sort of sweeping generalisations bandied about very rich developers or housing associations need to do the right thing. Leaseholders mustn't be left out of pocket, and a lot of it, I think, unfortunately, is being driven by principles and ideology from that end of the discussion. Whereas, I can understandably, housing associations and local authority landlords are just worried about the bottom line as to who's actually going to pay for all this. And it is frustrating, I think, looking from the legal side of things, to see that people like yourself, Scott, are really wanting to get this sorted and do what is the morally right thing by resolving the fire safety issues. But the problem is the money doesn't grow on trees, especially after the last 4 years. Even if there was any kind of illusion that housing associations had, the odd £10 million stuffed down the sofa, that money, as long as it was such as it was, has long since gone with the rent cuts, and also now the coronavirus crisis as well to boot. So I think it is a perfect storm of having a lot of work to do, and people being rather reluctant for anyone in particular to have to pay for it. And it's difficult to then work out how is the right way to share out the responsibilities for it going forwards. But I think it's important that we keep the debate going and try to try and find clarity on the way forward.
I think we may have run out of time there. But if anyone does have any questions, I will just quickly share my screen again and pop our contact details up. But thank you all for joining us. Thanks to Scott as well. Your input's been really valuable. And if anyone has any suggestions on other sessions they'd like us to run, then again, please do get in contact with us. Thank you.